Hello and good afternoon. Thank you for joining us today. My name is Carmen Jule, and today Sandra, Jensen, and I will provide an overview of compliance programs with an emphasis on federal and New York State requirements. We will provide an opportunity for questions after the presentation. In the meantime, please feel free to type in your questions. Your questions will be anonymous. This presentation will be emailed to you and will also be posted on our YouTube channel.
Hi, this is Sandy Jensen. While this webinar focuses on compliance requirements under New York law, we wanted to briefly touch on federal requirements you should be aware of. And those include requirements and guidance under federal sentencing guidelines for organizations, the U.S. Attorney's Manual, OIG Voluntary Compliance Program guidance, the Deficit Reduction Act, Affordable Care Act, and other federal requirements. So effective compliance programs could be considered when determining sanctions against an organization and its agents. The federal sentencing guidelines lay out criteria for effective compliance and ethics programs, and an organization that follows the guidelines may be eligible for a reduced sentence if charged with a criminal offense. And similarly, under the U.S. Attorney's Manual, this manual instructs federal prosecutors evaluating an organization's compliance program in making a determination as to whether to bring charges. It lays out some critical factors that the U.S. attorneys should consider in making this determination. And those include whether the compliance program is adequately designed for maximum effectiveness in preventing wrongdoing, and whether management enforces the program, or whether it's tacitly encouraging employees to engage in misconduct. Similarly, the OIG has developed a series of voluntary compliance program guidance documents. It's available on its website, and it's directed at various segments of the healthcare industry, such as hospitals, nursing homes, third-party billers, and durable medical equipment suppliers. The next few slides will provide more detail on the Deficit Reduction Act, the ACA, and the other federal requirements. So the Deficit Reduction Act, this requires entities that receive or make payments of at least $5 million under a state Medicaid plan in a federal fiscal year to have the following as a condition of Medicaid payment. So they must have written policies for employees and certain contractors and agents that provide detailed information about the false claims laws and whistleblower protections. They also have to have detailed provisions regarding the entity's policies and procedures for detecting and preventing fraud, waste, and abuse, and discussion in employee handbooks describing the above. Now, with respect to employee handbooks, if the entity doesn't have an employee handbook, that's fine. It's just if the entity does have a handbook, you would need to include references to the false claims laws and whistleblower protections and a compliance program and policies that address fraud, waste, and abuse. Under the DRA, in New York, entities must certify compliance with the DRA annually using an online certification form on OMIG's website. This certification must be completed during December that follows each federal fiscal year that Medicaid provider directly receives or makes $5 million or more in Medicaid payments. And the federal fiscal year starts on October 1st and ends on September 30th. When you go on OMIG's website and you click on the certification form, on the form it lists summary questions that help an entity decide whether it complied with the DRA. And some of the questions include whether the entity has written policies for all employees, including management, and any contractor or agent of the entity that provides detailed information about the Federal False Claims Act, remedies for false claims and statements, and state laws pertaining to civil or criminal penalties for false claims statements. It also asks whether the written policies address whistleblower protections and address the role of the Federal False Claims Act and state laws in preventing and detecting fraud, waste, and abuse in federal healthcare programs. Among the questions also are whether the entity has an employee handbook and whether the handbook includes the required information. OMIG just sent out an update yesterday, I believe, that announced changes to its certification. And the change was that they're transitioning from a system that utilizes the federal employer ID number to a system based on provider ID numbers. And they also include helpful contact information. So if you have any questions, they provided a phone number and email address for compliance-related questions. Other federal requirements are imposed under the Affordable Care Act. So in 2010, the Affordable Care Act mandated that all providers or suppliers establish a compliance program that contains core elements as a condition of enrollment in Medicare, Medicaid, and CHIP. And these core elements are really nicely described in a webinar that's posted on its website, and we provided the link for you there. And they include written policies, procedures, and standards of conduct, compliance program oversight by a compliance officer or a compliance committee, and training and education to all employees, managers, and supervisors, among other requirements. You should definitely check out the link in the webinar. Nursing facilities have additional requirements imposed on them. The recent overhaul of the long-term care federal regulations laid out additional compliance and ethics program requirements, and these require an effective system to prevent and detect criminal, civil, and administrative violations and promote quality of care. Now, these take effect in 2019, so you should definitely check out the regulations and understand the requirements that are imposed under that. Other federal compliance requirements are related to FQHCs, Medicare Part C and Part D providers, and accountable care organizations. Recently, HRSA issued a compliance manual which outlines 21 program requirements and how an FQHC can demonstrate compliance with these requirements. One requirement is with respect to conflicts of interest. So FQHCs must maintain written standards of conduct covering conflicts of interest and governing the actions of its employees engaged in the selection, award, and administration of contracts. And this applies to all health center employees, officers, board members, and agents. With respect to Medicare Part C and Part D providers, they have requirements that need to be met through their participation in the plan. CMS doesn't outline how providers are to comply, but instead they require that the requirement is on the plan to ensure that its providers meet certain compliance guidelines. And finally, accountable care organizations are required to have a compliance plan that includes a designated compliance official and who specifically is not its attorney and reports directly to the board. It must have mechanisms for identifying and addressing compliance problems related to the ACO's operations and performance, and include a method for employees or contractors of the ACO, ACO participants, ACO providers and suppliers, and other individuals performing functions or services related to the ACO activities to anonymously report suspected problems to the compliance officer, as well as other requirements. Okay, so now we'll shift to compliance requirements in New York. So in New York, certain providers who participate in the Medicaid program have to develop, adopt, and implement effective compliance programs. These required providers have to certify annually that they have adopted, implemented, and maintained a compliance program that meets the state law requirements, and those are in social services law and the implementing regulations. And this is different than the annual certification that's required under the DRA that I had previously mentioned. So who are required providers? These would be persons or entities that are subject to public health law, Article 28 or Article 36. And so your Article 28 providers include hospitals, diagnostic and treatment centers, and nursing homes. And your Article 36 are the home health agencies, your LICSAs and CHAs or certified home health agencies. Required providers are also persons or entities under Article 16 or Article 31 of the Mental Hygiene Law. And your Article 16 are your clinics that are certified by OPWDD to provide clinical services to individuals with developmental disabilities. And the Article 31s are your facilities and programs providing services to persons who suffer from mental illness. And finally, a required provider also includes other persons, providers, or affiliates for which the medical assistance program is or should reasonably be expected to be a substantial portion of their business operations. And substantial portion is defined as a person who, in any consecutive 12-month period, claims or orders and/or can be reasonably expected to claim or order Medicaid services or supplies of at least $500,000, excuse me, or receives Medicaid payments or can be reasonably expected to receive payments either directly or indirectly of at least $500,000, or submits Medicaid claims of at least $500,000 on behalf of another person or persons. So it's important to note that this includes indirect Medicaid reimbursement, not just fee-for-service payments, but it also includes payments received from Medicaid managed care organizations. And with the last bullet, a person who submits claims on behalf of another. This would also apply to billing companies who submit claims on behalf of a provider. So a billing company would have to have a compliance program as well. So New York statute and regulations require that to be effective, a compliance program has to include 8 elements. And this is required under social services law and the implementing regulations in Part 521. And so the first element is written policies and procedures, or a code of conduct or codes of ethics. So the written policies must include a description of the compliance expectations, implement the operation of the compliance program, provide guidance to employees and others on dealing with compliance issues, to name a few. The compliance program must also include a designated employee responsible for the day-to-day operations of the compliance program, who reports directly to the CEO or designee and directly to the board on a periodic basis. Now, this person's duties may solely relate to compliance or it can be combined with other duties. The compliance program must also include periodic training and education on compliance issues, expectations in the compliance program operation for all affected employees and associated persons, including executives in the board. We'll talk about who affected employees are a little bit later. The compliance program also must be accessible, must include accessible communication lines to the compliance officer, including methods for anonymous and confidential good faith reporting. So accessible communication lines to the compliance officer must be available to all employees, persons associated with the provider, and executives in the board. Continuing with the required elements, the compliance program must include fair and firmly enforced disciplinary policies, which include sanctions for failing to report suspected problems, participating in non-compliant behavior, or encouraging, directing, facilitating, or permitting non-compliant behavior. It can appear to be tacitly encouraging, that the entity is tacitly encouraging the behavior. Your policies need to specify what's going to happen if any of the requirements aren't met or the policies aren't followed. The elements must include, the compliance program must include a system for routine identification of compliance risk areas specific to the provider for self-evaluation. These include internal and, as appropriate, external audits, and for evaluation of non-compliance, credentialing, mandatory reporting, governance, and quality of care of Medicaid beneficiaries. Another element, a system for responding to compliance issues, for investigating and correcting, and for reporting to DOH or OMIG, and for refunding of overpayments. And the last element, the compliance program has to include a policy of non-intimidation and non-retaliation for good faith participation in the compliance program. And to be effective, the compliance program has to be applicable to the main areas of an entity's organization, including billings, payment, medical necessity and quality of care, its governance, mandatory reporting, credentialing, and other risk areas that are or should, with due diligence, be identified by the provider. So as we said, this applies to, the compliance program has to apply to affected individuals. And who are affected individuals? The Part 520 regulations that I had mentioned in the previous slides require that a provider's policies and procedures provide guidance to employees and others dealing with potential compliance issues. OMIG, in their guidance, interpreted the people covered under a provider's compliance program to include the listed affected individuals. They include all affected employees, affected appointees, executives and governing body members, any person or affiliate who is involved in any way with the required provider, such that the person or affiliate contributes to the required provider's entitlement to payment under the Medicaid program. And this would include independent contractors, interns, students, volunteers, and vendors. And also includes individuals who are at least a 5% owner of the required provider. And now I'll turn it over to Carmen, who will talk about enforcement.
Thank you, Sandy. So we'll now discuss how OMIG has gone about assessing compliance programs. Initially, OMIG commenced assessing compliance programs of required providers who were required to certify compliance with the social services law and the implementing regulations, and who failed to do so. So this would include providers under Articles 28 or 36 of the Public Health Law, Articles 16 and 31 of the Mental Hygiene Law, and those who met the billing thresholds for mandatory compliance programs. Since then, OMIG has begun conducting compliance program assessments and reviews of required providers who have certified in past years. To date, the OMIG Bureau of Compliance, or the BOC's, approach has been to conduct compliance program desk reviews. These desk reviews are meant to take a snapshot in time. That is, they are intended to capture the status of the provider's compliance program at a particular date. Desk reviews consist of requests for documents and information. As part of the desk review, the provider must also complete the Compliance Program Assessment Form. This is the form it uses to identify the documents that are evidence of it being in compliance with the 8 elements that are required for a compliance program. As part of the desk review, the BOC may also request additional follow-up. Please note, your attorney may participate in the process. Upon completion of the desk review, the BOC will issue a draft assessment report. In this report, the BOC will share its results and any deficiency findings with the provider. It will also provide a deadline for the provider to submit additional explanatory information or documentation that may be helpful for the BOC's consideration. The BOC will then issue a final assessment. If the BOC has found deficiencies, The final assessment will serve as a notice of its determination that the provider failed to submit sufficient evidence to prove that its compliance program satisfactorily meets the requirements of the social service law and the implementing regulations. The provider is required to take immediate action to correct the identified insufficiencies to mitigate the impact of the provider's failure to comply with its mandatory compliance program obligation. Additionally, if there are deficiencies found, the BOC does reserve the right to confirm that the provider has implemented plans of correction, and it may do so by conducting an unannounced site visit at its initiative and in its sole discretion. Now, to the extent the BOC has determined that it will conduct an on-site review, please note that these reviews are very comprehensive. As with a desk review, OMIG is assessing the status of the provider's compliance program at a given point in time, a specific date. In preparation for an on-site review, the BOC may issue documentation requests. These requests can be very detailed and voluminous, depending on the provider's organizational structure and size. And I'll briefly outline examples of the types of documents and information that the BOC may request. The BOC will probably request information concerning contact information for certain individuals, such as the compliance officer, CEO and COO, the chair of the governing board, and the chair of the governing board committee that has oversight responsibility for the compliance program. The BOC will probably require that the provider complete a compliance program assessment form. Again, this form is based on the 8 elements that are required for mandatory compliance programs. When completing this form, the provider would have to include citations to specific documents, pages, and paragraphs that provide evidence of compliance with each given element. Providers may be requested to submit copies of their respective compliance plans, code of conduct, and compliance program policies and procedures. The BOC may request information about the compliance officer, such as a job description, resume, copy of recent W-2s, and a recent personnel performance review. The BOC may request copies of the governing body resolutions to implement the compliance program or to appoint the compliance officer as the employee vested with the responsibility to oversee the program. The BOC may also request organizational charts, not just of the provider, but also its relationship to affiliates. The BOC may require that the provider submit documents related to compliance training materials and also evidence of training. Evidence of training may include signed acknowledgements, certificates of completion, or sign-in sheets for training sessions. The BOC may require documents that identify compliance risk areas. It may ask to see the annual compliance work plan, and will also request copies of applicable operating certificates or licenses and organizational bylaws. Additionally, the BOC may request information regarding employees in the compliance department or who have compliance functions. With respect to the compliance officer and employees in the compliance department, the BOC may request information about the compliance-related functions as well as the individual's non-compliance-related functions. The BOC may also request information regarding committees that have compliance or risk management oversight. And depending on the provider, this may be a committee of the board or a subcommittee of the governing board, or a committee that works closely with other committees such as risk management or QA. Examples of documents that the BOC may request include copies of committee minutes or reports. As part of preparation for an on-site review, the BOC may request to see federal or state regulatory reports, audits, or reviews, evidence of how compliance issues are raised to the provider's governing body, and evidence of budget reports, which basically serve as evidence of resources that are provided for the compliance program. Providers may also be asked to submit call logs to their compliance hotline or helpline if they have one, investigative logs, investigative files, and compliance risk assessments. Now, depending on the provider, the BOC may also ask to see evidence of how compliance information is communicated, and this can vary depending on the provider. Some providers have an intranet system, others use email blasts, some use a combination of hard copy electronic mechanisms. The point is that the BOC will, in all likelihood, want to see how the provider goes about disseminating compliance information to affected individuals. This could include, for example, revisions to existing policies or disseminating notice of a new policy related to the compliance program. The BOC may also request to see a roster of employees or contractors who provide patient care or billing services on behalf of the provider. It may request copies of personnel files of certain staff members. This would be presumably to identify compliance training, disciplinary action, and reveal any issues related to retaliation and intimidation for good faith participation in the compliance program. The BOC might also ask the provider to submit evidence of compliance self-assessment tools or plans of correction to address any areas that need improvement. In addition to requesting documents for review in advance of a site visit, or even to be provided on the day of a site visit, the BOC may request to conduct interviews. Some of the individuals the BOC may want to meet with is the CEO, the COO, other compliance staff, the chair of the board-level compliance committee, the CFO or other billing staff, human resources, risk management, the compliance trainer to the extent the compliance trainings are conducted in person, and other staff. Your attorney may be in attendance. If a provider is non-compliant with applicable requirements for implementing and maintaining an effective compliance program, OMIG is authorized to take action. Specifically, New York State regulations authorize OMIG to impose any sanctions or penalties permitted by federal or state laws and regulations if a provider does not have a satisfactory program. This may include revocation of the provider's agreement to participate in the Medicaid program. Additionally, the public health law authorizes OMIG to make referrals to regulatory agencies and the applicable licensure boards, withhold payment of Medicaid funds, impose administrative sanctions and penalties, exclude providers from participation in the Medicaid program, or impose a corporate integrity agreement, or CIA. Now, with respect to CIAs, CIAs include mandated compliance program requirements and standards. CIAs usually run for a 5-year period. As a term of the CIA, the provider has to engage an independent review organization at its own expense. The independent review organization is generally required to submit reports regularly to OMIG during the course of the CIA. Additionally, the CIA imposes specific reporting obligations to OMIG. Deliverables under the CIA must demonstrate that the provider has an effective compliance program that meets the Medicaid program's requirements. Providers who are operating under a corporate integrity agreement should diligently comply with the terms of the agreement. At any point of the CIA, a material breach of the terms could lead to the provider's exclusion from the Medicaid program. CIAs and their related compliance requirements follow the organization even if there is a change of ownership. It's worth noting new owners of the entity would still be required to abide by the terms of any CIA that is in place. I'll now discuss some various resources that are available to providers as they go about implementing their compliance programs. These resources have been published by OMIG. They are available on the BOC's Compliance Library online, and we've provided the link for you. One of the big pieces of guidance published by OMIG is the Compliance Program Review Guidance. It was published in October 2016, and it provides clarification and information in connection with each of the 8 elements of mandatory compliance programs in New York. This is general guidance, and it can be a valuable resource for all types of providers. Additionally, OMIG has published specific compliance program guidance for general hospitals and for delivery system reform incentive payment, or DSRIP, providers. These are also available on the BOC's Compliance Library website. Additionally, OMIG has published other guidance in connection with certain aspects of the certification process or compliance program elements. As Sandy mentioned earlier, today OMIG clarified how its certifications will proceed going forward based on the provider Medicaid provider numbers. That was published on their website. Additionally, OMIG has identified and published compliance risk areas for certain types of providers, such as transportation providers, Medicaid service coordination providers, CHAs, and others. Providers can also go online to find OMIG's work plan, which provides information as to provider-specific risk areas. The compliance program self-assessment form is also available online, which is useful in preparing for a BOC desk review. OMIG also has several webinars online. Some of them are listed here for you. Recently, OMIG published the general results of its past compliance program reviews and assessments. These reviews and assessments were conducted from January 2015 through June 2017. The results reflect the percentages of insufficiencies with respect to the specific required elements of the compliance program. So I'll outline here, based on each of the 8 elements, the top areas of deficiency, the deficiencies with the highest percentages. So with respect to element 1, having written policies and procedures in place in accordance with mandatory compliance programs, 24% of the providers audited did not have written policies and procedures in effect that provide guidance on dealing with potential compliance issues for all affected individuals. With respect to the second element, having an employee vested with the responsibility for the oversight of the compliance program, 31% of the providers audited were unable to demonstrate that the compliance responsibilities were satisfactorily carried out. 13%, for 13% of the audited providers, the designated employee did not periodically report to the governing body on the activities of the compliance program. As you can see here, with respect to element 2, OMIG identified 2 different areas where there were insufficiencies within this one element. If there was insufficiency with one aspect, then this provider was cited with not having met the requirements of the element. OMIG has identified what it considers to be significant insufficiencies with respect to compliance program training and education requirements. For 55% of the providers audited, periodic training and education on compliance issues, expectations, and the compliance program operation were not sufficiently provided to all affected individuals. 47% of the providers audited did not provide training as part of their orientation for those same categories of affected individuals. Included here are providers who failed to define the timing of their periodic training or who failed to define and identify for the BOC when orientation occurs, and or failure to identify categories of affected individuals that for some reason do not receive training and education. With respect to element 4, having lines of communication, 47% of the providers audited did not have a method for anonymous and confidential good faith reporting of potential compliance issues as they are identified. Now, a word of note, OMIG has in past guidance clarified that a provider must have at least one anonymous method for reporting potential compliance issues and at least one confidential method for reporting compliance issues. The anonymous method and the confidential method may be the same method, but they do not necessarily have to be the same. Further, there is nothing to preclude a provider from implementing additional methods for reporting potential compliance concerns. But at a minimum, one method must be anonymous and one method must be confidential. And with respect to the confidentiality of compliance reports, OMIG has in the past clarified that it expects the identity of an individual who reports a compliance issue or a potential compliance issue will be kept confidential unless the matter is turned over to law enforcement. The fifth element, having disciplinary policies in place. 29% of the providers that were audited did not have policies in effect that articulate expectations for assisting in the resolution of compliance issues. 23% did not have disciplinary policies that encourage good faith participation in the compliance program. And 21% did not have a policy in effect that outlines sanctions for encouraging, directing, facilitating, or permitting non-compliant behavior. With respect to element 6, having a system for routine identification of compliance risk areas, 17% of the providers did not have any evidence of a system in effect for the routine identification of compliance risk areas specific to the provider type. OMIG has clarified that examples of documents that would demonstrate that a provider has a system in place for the routine identification of compliance issues would be work plans or audit tools. Also, in another deficiency in this element was that 15% of the providers who were audited did not have evidence of a system in effect for self-evaluation of the risk areas. This would include internal audits and, as appropriate, external audits. And 19% did not have a system in effect for the evaluation of potential or actual non-compliance as a result of audits and self-evaluations. The BOC expects to see documents that outline the provider's system for evaluating the cause of compliance problems. With respect to element 7, having a system for responding to compliance issues, 31% of the providers who were audited did not have a system in place for identifying and reporting compliance issues to the Department of Health or OMIG. And 23% did not have a system in effect for correcting compliance problems promptly and thoroughly. And with respect to responding to compliance issues, the BOC does recommend that providers be able to identify examples of prior refunds of Medicaid overpayments as may be applicable. And lastly, in connection with the 8th element, having a policy of non-intimidation and non-retaliation, 44% of the providers that were audited did not have a policy of non-intimidation and non-retaliation for good faith participation in the compliance program. This is a key because the BOC requires that the policy address both non-intimidation and non-retaliation. Good faith participation in the compliance program would include things like reporting compliance issues, investigating issues, self-evaluations, audits, remedial actions, and reporting to appropriate officials pursuant to Section 740 and 741 of the New York Labor Law. So that's a summary of OMIG's findings based on approximately 2.5 years worth of conducting compliance program reviews. Now, OMIG is not the only government entity that may conduct a review of a provider's compliance program. The Department of Health and Human Services Officer Inspector General and the Centers for Medicare and Medicaid Services may also enforce. Now, in our experience to date, the OIG compliance reviews have focused on how providers comply with regulatory requirements related to billing and providing services. Notably, the OIG's reviews have not related directly to the existence or the maintenance of the provider's compliance program. Similarly, CMS's enforcement actions against Part C providers and Part D providers have not directly related to the compliance program that those providers had in place, or the lack thereof. However, the Part C sponsors, also commonly referred to as Medicare Advantage plans, and Part D plans do conduct compliance program reviews as part of the provider's participation agreement. In our experience, Part C sponsors and Part D sponsors actively conduct these kinds of reviews of their first tier and downstream providers. The Part C and Part D sponsors are obligated by regulation to ensure that their first tier and downstream providers have received certain minimum general compliance training and training on fraud, waste, and abuse, among other things. Additionally, the Part C and Part D sponsors may contractually require that their participating providers implement or conduct certain compliance activities. Now, while Part C and Part D sponsors are required to ensure their first tier and downstream entities and providers have met certain minimum training requirements, they have flexibility and discretion in determining how to go about assessing the provider's compliance. In our experience, we've seen some Medicare Advantage plans ask that providers complete attestations periodically. Others will conduct comprehensive reviews that are similar to the desk review or on-site review that OMIG could potentially decide to conduct. This would include requests for documents, on-site visits, or interviews. And the process and follow-through and time frame will vary depending on the Part C or Part D sponsor that is conducting the review. Providers should be aware that they may be contractually required to participate in these types of reviews. Now, at this time, we'll be able to take some questions. Okay, so one of the questions, somebody asked to clarify what the OMIG BOC stands for. It is the New York State Office of the Medicaid Inspector General Bureau of Compliance. This presentation, another question posed is whether this presentation will be available. It will be available, it will be emailed to you, and it will also be available on our YouTube channel. The next question, does our compliance officer have to be a W-2 employee? Also, can our compliance officer have another role at our company, such as CFO? In response to this question, OMIG has published guidance reflecting that the employee who is vested with the responsibility of the day-to-day operation of the compliance program should be an individual who qualifies as an employee for New York State or federal employment tax purposes. A W-2 would be a strong indicator of that fact. With respect to whether or not they can have another role at the company, the BOC recommends that the compliance officer not be in the financial or legal departments. This is because of the potential for a conflict of interest. It's basically recommended that the compliance officer not be involved in the claim submission or billing process or involved in any other department that could be related to a potential compliance risk area. The next question, what is the process for an OMIG Compliance Program review? Okay. Well, in our experience, providers will receive a letter or notice from the Bureau of Compliance. That letter or notice will have information about a due date for when documents are due. To the extent that the Bureau of Compliance may decide to do a subsequent on-site visit, it has been our experience that OMIG similarly provides written notice of the date of the on-site visit and any deadlines for submitting information or documents leading up to the date of that visit. The next question, can we meet our compliance training obligation by giving all of our employees the code of conduct and copies of our compliance policies and procedures? The answer here is no, that alone would not satisfy the compliance training and education requirement pursuant to OMIG's guidance for a couple of reasons. First, in our experience, based on OMIG's guidance and in our experience representing different types of providers in the OMIG Compliance Program reviews and assessments, OMIG expects that the providers will provide training to affected individuals and not just provide the training, but ensure that the affected individuals receive the training materials, understand them, and have an opportunity to ask questions. There's, from a practical matter, there's different ways providers can go about this. Some providers use self-study programs or training modules. OMIG actually recommends using like a post-training quiz or test. It's not required, but it is recommended. And also, it would not be enough to give the training just to employees. As Sandy mentioned earlier in the presentation, the term affected individuals, how OMIG interprets the applicability of the compliance program is more than just employees. You have to provide training to all affected individuals, which includes also appointees, executives, members of the governing body, and any persons or entities affiliated with the provider to the extent that person or entity or affiliate contributes to the provider's entitlement to reimbursement from Medicaid. this could implicate, independent contractors, volunteers, students, vendors, and affected individuals. Separate and apart from that also includes individuals who are at least a 5% owner in the provider. So it is not sufficient to just provide the training to employees. And as was pointed out in one of the slides relating to the OMIG's, the results of OMIG's past assessments, to the extent that a provider does not provide a certain group of affected individuals with, for example, orientation training, if OMIG conducts a desk review, a compliance program desk review, they will want to see why certain categories of affected individuals did not receive training at orientation, and if so, when compliance training was in fact provided. Because if the person is an affected individual, they have to be trained. So you, as a provider, you want to be able to explain why some people don't get an orientation, and if so, show that they otherwise did still get the compliance training. At this time, we want to say thank you for participating. We hope that this webinar was informative, and we look forward to seeing you at our next webinar, which is September 26th. Thanks very much.